Hello everyone, welcome to RedBus channel. In this video, we'll look at the most recent proposed rule to modernize H1B visa program, which include many things around H1B lottery and other things. Yeah. So what we'll cover in this article, in this video today, is more around the background, how this actually started, what are the changes that are coming in, and what are the existing ones that are actually kind of codified, which are basically made as official rules, and next what to expect right on the next steps. So this is what we'll cover in this video. So if you haven't subscribed to our channel, do subscribe for getting regular updates. So first thing, how did this happen, right? If you looked at the news, on Monday, in fact, this rule was published in Federal Register. Is a screenshot of that, what appeared in the Federal Register. As you can see, it's 10/23 is when this was actually put in. So you can we'll actually put a link in the description as well for you guys to have a look at it. So just to give you a background, this is not something new. This has been in the works since spring of 2021, and it's been pushing for a while. And now finally in spring of 2023, we have this proposed rule. So what you're seeing is a snapshot of regulatory agenda that usually the administration publishes twice a year, what their priorities are. As you can see, they've been wanting to do this for a while, but finally it is now happening. Now, if you look at the overall, the regulation that is proposed, it's a 227-page document. You can download the PDF, but we look at the the Federal Register. It is currently available as a piece of text, but you can also look at the PDF. It's actually a large PDF. So what they cover, or they're structured into three key areas, right? So one is modernizing the program. What they mean by that is basically changing some of the fundamentals of the H1B visa program on how they adjudicate or basically make a decision. It could be related definitions, on how to increase overall efficiency. The second one is they want to provide additional benefits or flexibilities for H1B visa applicants, including F1 visa holders. So this is the second, area where they are focusing on. And the third one is they want to increase integrity of the program. What they mean by that is basically adding guardrails, where there's a lot of fraud involved and all, right? How can they avoid such fraud? So kind of putting in place some rules so that people can't abuse the system. So that's what it is. So this is the overall structure. So what we will do is we will actually cover it in two sections. So one is we look at a new proposed changes first, and then we will just look at what has been codified. So the first section is more on new proposed changes. So the first one is H1B Visa Lottery. One of the biggest problems, if you see H1B Visa Lottery, this year there were about close to 800,000, registration that were submitted, and there's a lot of fraud involved in that, right? I mean, you can basically see by the numbers, right? So what they want to do is, limit the fraud in that. So they want to remove, basically, based on the number of registrations, to based on unique passport number. So in the past, there was an option to submit an applicant details without passport number, but now they want to basically change that and put it as a way to select based on the unique passport number. So what happens is, let's say you have multiple offers from multiple different companies, then you would still get only one entry. So there is no advantage for you having 10 offers. So this is where, people with consulting companies were kind of doing the fraud, where they had like 10 plus offers to increase the chances. So now this will not happen, because even though how many offers you have, you will still be based on your passport, and you will only have one chance at it. Yeah. So if let's say you selected, imagine you are a genuine candidate, you get, you get selected in Google as well as in Microsoft. Now you get, both of them are submitted, and you still get one entry, and you got lucky and get picked in the lottery. Now what happens once you get selected is both of these employees will be notified, and it's from then, that's when they take the call to submit or not, right? And again, this is a very, very good move in general. So they plan to implement this from the next fiscal year. This is what they plan, again, if everything goes well. So again, things may or may not, depending on how it progresses, it may or may not happen. Now, in terms of the second one is the cap gag to be extended till April 1st of next year. So traditionally what happens is you get cap gap until October 1st. So for those of you who are not familiar, cap gap is when your OPT is expiring, and then there is a gap between when the OPT expires and October 1st. So until you get the decision on your H1B, so that is cap gap. So there is a provision for you to work until you get a decision. So currently the decision, the cap gap is only until October 1st. So they want to change that to extend it until April 1st of next year. So what it means is that, let's say you get selected in H1B visa lottery for next year, FY 2025, and let's say you want to file in June, but you don't get your decision until November. In the past, you would have to stop working from October 1st. Now you can continue to work until April 1st. So they're giving you more flexibility so that you don't lose your state, you don't lose your employment opportunity. So that's actually a good thing for F1 students. Yeah. Now, in terms of another important thing is they want to encourage entrepreneurship. So this is where they've said, let's say you are a founder and you own majority of the company, which means you're more than 50% of the company. Technically you can sponsor your H1B visa for yourself even if you own the company, but there were some rules on controlling and all that did not allow a proper I would say proper way to use this. But now, let's say you own more than 50% of a company, then what they say is, you should spend more than 50% of your time on specialty occupation related duties. So what this means is, let's say you're a software engineer and a founder, right? And you own over 50% of the company. Let's say you got a great idea and you started a company and you got funding from large VCs, right? Now you own more than 50% still. In that case, you have to spend 50% or more than 50% of your time on software engineering tasks. But the rest of them, you can do administration, you can do whatever you want, right? So this is a big advantage. That's what they're saying. So the whole idea is they want to encourage H1B visa holders to be able to start companies. Again, this is something, there are some loopholes, we'll see how they'll address, because let's say somebody loses a job, then they could technically bootstrap and start a company and do kind of, but there are potential to do some abuse as well. But we'll see how what it pans out at the end of this, right? But overall, this is a good move, right? It provides a lot of opportunity for good founders to be able to start a company. So one catch is that you only get 18 months of initial approval. Basically, let's say you apply and you get approval, then it's going to be 18 months only, and after that you get extension also to 18 months, subsequent to that, then only you get 3-year extensions. So this is slightly different from your the current approval process, which is a 3-year typical extensions or 3-year approvals. Yeah. Moving on to the next one. So they are changing the definition of specialty occupation. They kind of doing some of this, but they are making it as a law or in the rule book, right? But what the fundamental is that, they say that you need a specific degree rather than a general bachelor's degree. What it means is, let's say you are, that the position to be qualified as a H1B position, you can't, the employer can't list just general MBA or general engineering degree, because what is happening is, let's say somebody has a degree in civil engineering and now they suddenly are doing machine learning and AI. So they're kind of not related, right? So they're saying, just say, let's say you want to get H1B position, then you need to be specific to that position or job duties. You can't say anybody with engineering degree. So this is an important change. This is kind of not problematic for people who have already experienced, because they can show that that experience equals. But if you're a fresher, then it'll be slightly tricky, because it's going to be hard for you to show the experience. This is going to be a challenge. Let's see how that will pan out, right? And in terms of site visits, in the past, FDNS used to do site visits. They were not mandatory. It was a voluntary program. You could choose to opt out. But now it is mandatory, right? So that's what they're planning to, put it in that regulation, that now they can technically come and visit your home or your client location, and you have to cooperate. Let's say they want to see records of anything, you want to talk to your manager. All of this has to be done. If not, they could technically revoke or deny your existing petition, right? So it's an important big change. So there's going to be slightly tricky how clients will cooperate and all of these things. Yeah, we'll have to see. Another important thing is more around Again, this is more of an administration thing, but let's say in the past, you would get a situation where you submitted, documents, or trying to do motion to reopen or RFE kind of things, right? So then, you would have requested certain dates for approval, but they would have passed. The dates would have passed because they took longer to process. So DHS is saying that they want to propose telling that, let's say, even though that expired, there will be an option to submit LCA and other new documents and give new dates for approval, so that this basically, if the petition was deemed to be approved, then they need to really approve. It's kind of like a good thing, in situations like this, right? And also another one is start date any time of the fiscal year. In the past, you had to had October 1st as a start date, but now they're giving flexibility that you can have it anywhere in the fiscal year, meaning between anywhere from October 1st of that fiscal year until September 30th, you can have any time. This is for planning and other things, right? So this is another one. Another change is more around cap exemption flexibility. So this one is also very important. In the past, it used to say just majority of the time. Now they have said that it is going to be at least half of the time. So the example for this is, let's say you have filed a H1B through cap exempt, right? Cap exempt is essentially universities, non-profit research organizations, all of these fall under cap exempt, right? So let's say you got your major here, first H1B on this cap exempt non-profit research organization. Then all you need to do is you need to work up to 50% of the time only to that non-profit. So for the rest of it, you could 50% or rest 50% you can work for any for-profit company like hospital or anything, any for-profit. So what this helps is, let's say this gives more flexibility for people who are in high demand to be able to not go to the lottery, but still work for research and also work for profit. So it's going to be a good thing actually, for encouraging more people to use the for profit. So that's about until now what we looked at are the new H1B program changes. Now what we look at is existing program practices or rules that are codified, meaning technically they were in policy alerts or policy documents, but they're not really codified into regulation, right? Now what they're doing is all these ones that we'll cover they're codifying it, making it part of official regulation. So it's actually set on stone, right? So amendments, this is nothing new. This has been there's been a policy that they've been following as a matter of similar solutions. So they're going to codify that so that when amendments needs to be done, LCA requirements for all of that, right? So now second one is deference for approvals. Basically what it means is let's say you had an approval done in the past. Now, the new, if nothing has changed, let's say for the same parties and more facts are all same, then they would have to give priority to the past approval and just approve it. So they don't have to re-look at the entire petition approval, right? So this is also another important thing. This also was there, you need to submit proof of maintenance of status. Now they're saying, you need to, again, they're codifying it. Also, there are some clauses where they say, they need quarterly tax documents and all of that. We'll have to see how this will pan out, right? But again, this is not a new practice though. So they're also removing itinerary requirements. This is not mandatory in the past based on a lawsuit, right? They're just codifying that you don't need a detailed itinerary, right? That you need to do X, Y, Z on a particular date and all of that. They're removing that. Again, this registrations as was always written there, but they're codifying that related companies cannot submit multiple registrations. So again, this was in the past for petitions, but not for registrations. And companies now they're making it codifying for registrations as well. And again, attestation was also kind of done in as a policy, but now they're making it as part of law because somebody said that it is not part of law. So they're making that also. You can't do false attestations and all of that. If you do so, then they'll revoke it, right? So the one is bona fide offers. This is contracts, non-speculative. These are all nothing new. Let's say you need to have a real offer. If they ask, you need to submit contracts, work orders, and all of that. And it can't be you can't just say some generic position in the future. So again, this is all not new. They've been following. They're just making as part of law, right? And also removing of employer-employer relationship. In the past, they had this Neufeld memo that was used in the past, but they're removing that now. That is not applicable anymore. That's also making as part of it, right? And also basically they'll now in terms of adjudication they'll look at the LCA, SOC codes and all of that. They're also making as part of the thing. Again, this is not new. So this is slightly new to some level. They want to ensure in third party placement the person has to be working in a specialty occupation. What it means is, let's say you are placed at a client site, you can't be doing some random work. You have to do a specialty occupation work. Again, they're codifying this as well, right? So that's about it, folks, in terms of what's coming in. Now, in terms of next steps, right? So DHS is giving 60 days, time period for public comments. So that's what it will, you get 60 days to basically answer. And, this is currently an NPRM step, which is basically notice for public for basically, getting these things moving. It's a 9-step process. I'll put a link in the description. You can see what the steps are in detail. So anybody as an individual or organizations, law firms, they get until December 22nd to submit comments. After that, they will actually review and submit the final rule. Very, very important. Until the final rule is published, nothing we discussed so far is implemented. Don't be under assumption that this is all real. Whatever we talked is actually a proposal. Until the final rule is done, nothing is nothing is final. So don't believe in others trying to scare you and all of that, right? Again, thank you for watching. Do subscribe for getting regular updates.